Welcome. Today we're going to discuss a growing issue in IP that has affected a number of our clients. We are living in the golden age of the copyright troll, and unless we all start preparing for their attacks, we could be left negotiating against ourselves for the right to pay thousands of dollars to make them go away. My name is Scott.Slavick. I am the co-chair of Barrick's Intellectual Property Group. I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, or searching and clearing new global brands on a rush timeline, or reviewing new marketing programs, or advising on risks with respect to social media marketing, I'm happy to help. What is trolling? The term copyright troll was coined to describe copyright owners who aggressively threaten litigation over online use of their copyrighted materials in the hopes of extracting exorbitant licensing fees. This tactic has become very popular because of statutory damages and attorney's fees provisions in the U.S. copyright law, which can increase a defendant's monetary exposure many times higher than the typical copyright license fees. More recently, however, the types of troll demands have changed. Trolls have begun using automated processes to find online infringements, making their ability to find even the smallest uses that much easier. The trolls are registering their copyrights in advance of contacting defendants and are often filing suit before sending a demand letter, intentionally ratcheting up the potential fees and making settlements that much more expensive. Some courts in New York, for example, receive multiple copyright infringement complaints a day, hundreds per year, all copyright troll related. Any business with a website or social media presence is vulnerable to copyright trolling. It's important to take demands from copyright trolls seriously and to deal with them promptly. Demands for fees often escalate over time, and the trolls are less likely to agree to a reasonable license fee after multiple demands, and especially not after they have filed suit. To best protect yourself, we recommend taking the following 7 steps. Step 1. Do not assume that any photo or other content you find online is free to use. There is a persistent, commonly held but false belief that content easily found online is available for anyone to use, or that if your brand is featured in a photograph with a hashtag referencing your brand, that you're free to use the photograph. That is not the case. Almost all online content is protected by copyright, and you will almost always need permission to reproduce it via web and social media, regardless of any accompanying hashtags. This is true for all entities, commercial or nonprofit. Step 2, don't assume that unauthorized use will qualify as fair use. The copyright doctrine of fair use may protect some unauthorized uses from copyright infringement. Unfortunately, there is widespread misunderstanding of this concept as well. Fair use does not correlate to our normal concept of what is fair, and there are no easy rules for what will qualify. There are a number of things that would seem fair, but don't qualify, including giving credit to the copyright owner will not necessarily excuse unauthorized use. Even if your product is depicted in the photograph, that does not mean that you can post the photograph without the photographer's permission. Fair use is a very difficult legal doctrine that involves looking at many factors with varied results in the courts. Before you decide any content is subject to the fair use defense, contact us so we can advise you on the relative risks of going forward. Step 3, find the copyright owner and get permission first. The old adage of it's better to ask for forgiveness than permission is the wrong strategy for dealing with today's copyright trolls. A better strategy is, if you're looking for photos online, don't just take an image from Google Images or from another's reposting. Use the information provided with the search results or reverse image search to find the site where the image was originally posted. Contact that site and confirm that they are the copyright owner and can grant you permission. If you're suspicious, ask for their copyright registration number and check it. Generally, it's safest to source images from reputable stock agencies such as Getty Images or Shutterstock and the like. You can also check Creative Commons to find all kinds of content available for various levels of licensing. When in doubt, don't use the content or call us to evaluate. Step 4, if you let others post content on your site, establish DMCA protection. As a website owner, you can be liable for infringement if you let your users post content to your site, even if you had no idea the content was infringing, and even if your terms of service prohibit posting infringing content. There is a provision in the Copyright Act called the Digital Millennium Copyright Act that can provide safe harbor from such liability, but only if you follow the required DMCA process. Step 5, obtain appropriate contracts and indemnification from your web designer and social media content providers. If you hire a vendor to design your site or run your social media presence, make sure you have a written contract with that vendor. The contract should have a recital that the vendor has obtained licenses for use of any third-party content. Ask to see those licenses. The contract should also include a provision that the vendor indemnifies you against any claims that content provided by the vendor infringes anyone else's intellectual property, including specifically copyrights. Keep a copy of the vendor agreement and third-party licenses safely in your files. You will need those to refute a copyright troll claim. We can advise you on appropriate warranty and indemnity language to include in your agreements. Step 6, consider purchasing advertising injury insurance. Many comprehensive general liability insurance policies include advertising injury protection. Depending on your level of activity on social media or how active you are with regards to your website, obtaining advertising injury insurance, although expensive, may still be the right plan for you. We can discuss the policy options and design provisions with you and help you decide whether such insurance may be right for you. Step 7, do not ignore a copyright troll demand. If you receive a copyright troll demand, take it seriously. Consult us to evaluate the situation and determine your best strategy as soon as you receive a demand from a copyright troll. Immediately remove the images in question. Confirm where you obtained the images, the circumstances surrounding its posting, how many views it received, and any other extenuating circumstances that might help explain the situation. A prompt rebuttal from a lawyer tends to be the most effective way to get the claim dropped or the money demand significantly reduced. Copyright trolls may have a cute name, but they no longer hide under bridges. They live out in the open and pose a major threat to your legal budget. We will be happy to audit your websites and social media feeds for any problems, as well as draft social media policies to help educate your employees as to the best practices for avoiding liability. Proactively addressing the proper use of copyrighted materials is the best way to avoid liability and the dreaded troll attack. If you have any further questions, please feel free to contact me or any of the Barrick lawyers that you typically work with, and we'll be happy to help you.